Good evening, members of the panel. Good evening, members of the panel. My name is Brandon Zhang, and I am with my co-counsel, Mark Maxwell Peter. We appear on behalf of the appellant, Mr. Antonio Fortuna. I will speak on two issues: the statement of appeal and whether my client's refusal to hand over his mobile phone was lawful. My co-counsel will then speak on the anonymous email and witness statements and whether the appellant violated Article 20 of the FDC. I will speak for 10 minutes and reserve 1 minute for rebuttal. Members of the panel, the respondent has imposed a sanction on my client for the alleged involvement of match fixing without regards to fundamental rights of my client and has not sufficiently proven that my client was guilty of any of the offenses. And as a result, we appear today before the panel to ask that it reverse the FIFA's appeal decision. Turning now to the first submission. The question is whether the statement of appeal is admissible, and this arises because the day of the receipt is in dispute. It is our submission that the statement of appeal is admissible for two reasons. First, the day of the receipt is 2nd April 2026, and second, we have submitted Exhibit 9 to show that the statement of appeal was submitted prior to the deadline. In the 2016 CAS decision of Ivan Bellado Palacios versus PFC CS.
Before you go to the cases, can you lead me to the CAS code provisions on admissibility? Or the timelines. We're talking about timelines now, right?
Yes. In paragraph, if I can direct the panel to paragraph page 5 of the record here at paragraph 26, the decision was fully upheld on 31st March by FIFA. However, the challenge decision with full grounds was sent on 2nd April 2026. And pursuant to Article 15, subsection 2 of the FIFA procedural rules, it explicitly provides that the time limit begins upon receipt of the full grounds of decision. And
Sorry, what does
Article 15, subsection 2 provides that the notification is deemed complete when the decision is communicated to a party, and subsection 4 states that decisions that immediately impose sporting sanctions against a party shall only be communicated with grounds. And here the day of the receipt of decision with grounds is...
Sorry, before we get there, you're referring to the FIFA, what code is it again?
It's the FIFA Procedural Rules 2025 edition. Procedural rules.
In relation to disciplinary?
Yes, because the dispute is over the day that the timeline begins.
But why is the Court of Arbitration of Sports bound to the FIFA rules? I'm bound to the CAS code, aren't I?
Well, it states that in the absence, the relevant article is Article Rule 49 of CAS Code, which gives a 21-day time limit in the absence of any rules by the sports governing body. But here, the FIFA rules under Article 50, subsection 1 is also 21 days. So the timeline is 21 days, pursuant to both of the CAS Code and the FIFA rules. And the dispute is whether the triggering day is the April 2nd of full grounds, or rather the operative motivated or the operative decision. In the 2016 CAS decision of Ivan Bellado versus PFC, at paragraph 74, the panel observed that Article 15, subsection 2 of the Procedural Rules 2008 edition provides that the timeline to appeal begins upon receipt of the motivated decision, which is also the full grounds as back in 2008.
What's the definition of motivated?
The motivated decision is the decision that is given but without the full legal reasoning and the reasoning behind the decision.
So in other words, it sets out the grounds of the decision, but it doesn't explain why it comes.
It doesn't. Yes, that's correct. It doesn't give the full legal reasoning.
And where do you get that definition?
That is a general definition, but there is that is a general definition.
I think there is somewhere which actually defines what motivated decision is.
Certainly.
If you don't have it now, that's fine.
Certainly.
You can take a look at it. I think it is one of the FIFA codes.
I will look in the FIFA codes there. In that case, the panel held that it was the day of decision with full grounds, which triggers the 21-day time period, and held that the statement of appeal was admissible. And in the present case here, we submit that it was filed within the 21-day time period, and that is reflected at paragraph 26 of the record, Exhibit 7, and the appellant there also paid the fee and filed the statement at 23:34 Iridonian time, and therefore it is our submission that the appeal is admissible.
23:34.
23:45 on the last day of the timeline, and pursuant to Article R32 of the CAS Code, I quote, "The time limits fixed under this code are respected if the communications by the parties are sent before midnight, time of the location of their own domicile."
So midnight is specified.
It is specified, yes, under Article R32 of CAS Code. And Iridonian shares the same time code as CAS, pursuant to the footnote number 3 on page 5 of the record.
Okay.
If there are no further questions, I will turn to the second argument here. In the alternative, it is our submission that even if the panel does not take that to be the day of receipt, we submit that it still it can be cured because we had submitted Exhibit 7, which was the email, to show that it was the email was sent out at 23:45, because there had been a cyber attack, and that cyber attack had because of the cyber attack, the email was not sent out. And I would like to introduce the CAS decision, the 2013 CAS case of AC Siena SPA versus Club Desportivo Nacional at paragraph 39. The appeal was filed 1 day later. However, the appellant submitted a shipment waybill receipt as evidence that it had been filed on the 19th, picked up by the Italian courier company on the 19th, and at paragraph 42, the panel held that the appeal was timely filed and thus admissible. And therefore, in the present case, particularly if I could ask the panel to follow me to page 5, paragraph 31, here it states,
31. Okay.
yes, page 5, paragraph 31, thank you. The statement of appeal was filed by email specifically, sent to the relevant email address at 23:45 Iridonian time on 23rd April 2026. This is Exhibit 8. And here we have submitted this evidence which proves that indeed it had filed the statement of appeal within the 21-day time limit, and therefore it is our submission that the statement of appeal is admissible. If there are no further questions from the panel, I will turn to submission 2. The respondent imposed a 5-year sanction and a fine of 100,000 Swiss franc when my client refused to provide his mobile phone to the investigation committee. It is our submission that the refusal was lawful for two reasons. First, the evidence does not sufficiently establish my client was involved in match fixing, and second, the privilege of self-incrimination is applicable. So turning to the first submission, we submit that my client, Mr. Fortuna, had not colluded with his father, and that the evidence is insufficient and can be rebutted. If I may direct the panel's attention to Exhibit 6 of the record.
Are we going to the text now?
Yes.
I just wanted to hear what rules of evidence is the panel bound by.
Yes, panel. The in cast jurisprudence has held that the standard of proof is a comfortable mere satisfaction of proof, more than a probability, more than a balance on probability, but less than beyond a reasonable doubt.
So where does that wording come from? Comfortable satisfaction. I mean, that is just one rule of evidence. I'm asking about what are the rules of evidence are supposed to be bound by.
At this juncture here, I am not able to make any submissions on the rules of evidence.
Even the one on the threshold of comfortable satisfaction.
Well, that one merely just states that it doesn't have to prove it beyond a reasonable doubt.
So where do you get it?
That has been held in multiple cast decisions.
And multiple cast decisions have not mentioned the provenance of that rule? Or you haven't seen them say such things?
I'm not quite sure which specific issues you're asking.
Because you are saying that there's a threshold of comfortable satisfaction before I can say that there's an offense which is made up. Where does that come from? Where can I see it? Could it be in the FIFA code somewhere? Could it be in the CAS code somewhere? Because right now you're telling me that you got it from cases, but surely the cases would have referred to some source of those of that rule itself. It's okay if you cannot find it right now, but just keep in mind there's a common question that
Right.
I'm sure just will ask.
Okay, thank you. So in Exhibit 6, at paragraph 14.
So we're going to the next now, right?
Yes. Exhibit 6, page 14, Exhibit 6 of the, it is Exhibit 6, but it's also reflected.
I have the new problem. There's a total of 57 pages. Which page should I refer to?
That would be page 15. 14, page 14, yes, correct, sorry, page 14.
Yeah,
You're there, right?
yeah,
Okay.
What
If the panel can turn to page 15, page 15. At the bottom, paragraph 6, here.
Hold on. I'm at page 15 of the record itself.
Okay, the bottom, paragraph 16.
I do not see a 16.
Okay, 16.
Well, what document are you referring to?
I'm referring to Exhibit 6, the document, but
Let me go to the there's no index.
I will find the relevant paragraph in the record for.
Exhibit 6, the witness statement of Mr.
Yes. Yes. Paragraph 16. It's also paragraph 19, page 4 of the record.
Okay, I see. 16.
Yes. So in paragraph 16, he states, I quote, "We tend to let conflicts simmer between us on basically any topic, and we may end up arguing on my diet or the way I decided to decorate my living room." And here, the appellant explains that he and his father may argue on any topic. And with respect to Exhibit 2, I quote, "In Exhibit 2, I recall hearing Mr. Antonio Fortuna telling his father to stop pressuring him, shouting that he simply could not go along with him in everything." And according to this statement, it directly contradicts any allegations for two reasons. First, it could be an argument over anything, and it is our submission that the inference drawn by FIFA has been too high and is not reasonably drawn. And second, the appellant directly refuses to do anything his father had asked him to do. And therefore, for those two reasons, it is our submission that the FIFA Appeal Committee had not demonstrated any real sufficient evidence to inference and conclude that the appellant had engaged in match fixing, particularly with his father. And
Sorry, I'm getting a bit confused. So, we are saying right now that the player's refusal to hand over his mobile phone,
yes,
when requested because of the investigation,
right,
that is a breach of some regulation,
yes,
which caused FIFA to impose some sanctions on him.
Correct.
That is in addition to the match fixing.
Yes.
Okay. So again, what regulations am I looking at?
The relevant regulation is Article 12 of the FDC.
Okay, disciplinary code.
Of the FIFA disciplinary
which
code.
Which is different
yes.
from the earlier one you stated, right? There was
yes.
Procedural code.
Yes, that's a procedural code. So the Article 12 is the relevant code, which does state that it falls that there has to be cooperation when requested to provide evidence. And here on this argument, we merely just assert that.
So, Article 12, right, you say?
Yes.
Does it have any exceptions stated therein where a player can rightfully or lawfully say that no, you will not have my mobile phone or my devices? Or has any other cases explored this particular provision or similar provisions where a player can raise his hand up and say, no, you are not entitled to get it?
Thank you, Mr. Presiding Arbitrator. And this brings me to my next submission, is the privilege of self-incrimination. In Article 12 of FDC, there is no exception stated there under the FDC. However, in the 2017 CAS decision of Jerome Valk versus FIFA, at paragraph 226, it states, I quote, "Where there are concurrent disciplinary and criminal proceedings, the privilege against self-incrimination appears debatable. In such a case, there is a real danger that the sports organization will be misused by public authorities to collect information that they could be otherwise unable to obtain. And in such circumstances, there may be, in the view of the panel, a valid claim by the party or witness concerned to refrain from delivering self-incriminating information." And in the 1996 European Court of Human Rights case of Funke versus France, at paragraph 41, the court held that the conviction by the criminal court for refusing to disclose the documents requested by the customs officer had violated his right to a fair trial under Article 6 of the ECHR and disregarded the presumption of innocence under Article 6 of the ECHR. And therefore, it is our submission that my client, Mr. Fortuna, had been violated of his right under Article 6 to a fair trial when there had been a sanction imposed upon the refusal of his mobile phone. And this is supported by Article 26 of the Swiss Civil Code, which is a procedural right as well under Swiss law. And therefore, in our present case, it is our submission that my client had a fundamental right to refuse evidence which may incriminate himself as well as his father, to refuse. And
sorry, you say fundamental. You keep saying fundamental right. Can you give me some examples of what are fundamental and non-fundamental rights?
So one example is the right to a fair trial under Article 6 of the ECHR and also Article 8 of the ECHR, which is a right to privacy. And here it is also arguable that there was a violation of the privacy of a right of privacy in requesting that my client hand over his mobile phone.
Is the right of privacy something that I have to consider as? I mean, what law am I considering?
The CAS panel has considered and has stated that the Article 6 of the ECHR must be taken into consideration. For example, in the 2011 CAS decision of Amos Adamu versus FIFA, at paragraph 66, I quote, "The panel is mindful that some guarantees afforded in relation to civil law proceedings by Article 6 of the ECR are indirectly applicable even before an arbitral tribunal, all the more so in disciplinary matters because the Swiss Confederation, as a contracting party to the ECHR, must ensure its judges guarantee a fair proceeding within a reasonable time." And the court then concluded and stated these procedural principles thus form part of the Swiss procedural public policy. If the panels have no further questions,
You haven't answered my second part of my question, which is what are non-fundamental rights?
what are non-fundamental?
You say there are fundamental rights like right to fair trial and so on. So what are non-fundamental rights?
So non-fundamental rights would be non-fundamental rights, for example, could be when requested to make a statement, such as in our case, the appellant was requested to make a statement, and he did, in fact, make a statement. And this is Exhibit 6 of the records.
So sorry. So what is the right we're talking about?
The right we're talking about here is the right to a fair trial. And here we argue that that right had been violated because
Sorry, as in you're saying there's a fundamental right that I recognize. Well, what is the non-fundamental right you're trying to talk about?
the non-fundamental right would be, say, for example, the refusal to provide a witness statement, a direct witness statement.
Okay.
I may defer to my further submissions there, Mr. Arbitrator.
Okay. Anything else?
This brings me to the end of my submissions. Thank you.
All good? Yep.
Good morning, members of the panel. My name.
Good morning. I thought your opposing counsel said was.
Oh, apologies, Mr. Arbitrator. Good evening, members of the panel. My name is Austin Seah, and together with my co-counsel, Mr. Ramesh Kanna, we appear on behalf of the respondent, the Federation de International Football Association, FIFA. I'll be speaking on the first two issues on appeal for 10 minutes, namely whether the statement of appeal is admissible, and secondly, whether the appellant's refusal to hand over his handphone was unlawful and the possible legal consequences that may ensue. My co-counsel, Mr. Kanna, will address the remaining two issues for 10 minutes, and we reserve 1 minute for a sir rebuttal. Members of the panel, integrity lies at the very heart of football as a regulated sporting activity. The effective enforcement of disciplinary sanctions, coupled with the mandatory duty to cooperate with investigative processes, is indispensable to maintaining public confidence in football. Any conduct tainted by corruption strikes the foundation of the game and is fundamentally irreconcilable with these principles. Today, the panel is faced with two choices. It can either affirm the sanctions duly imposed in defense of football's integrity, or they can choose to undermine the very mechanisms designed to protect sport from corruption and manipulation. In such circumstances, the sanctions imposed were not only warranted but proportionate, and the respondent therefore respectfully submits that the appeal must be dismissed. Turning to the first issue, we submit that a statement of appeal filed by Mr. Fortuna is inadmissible for three reasons. Firstly, the appellant had missed the deadline to file the statement of appeal. Secondly, the decision on 31st March is an appealable decision, making the deadline 21st April. And lastly, the appellant had missed the deadline to file the appeal brief. Turning to the first argument, we agree with counsel for the appellant that Article 50, subsection 1 of the FIFA statute is applicable here. And as noted in the 2023 CAS case of Wolverhampton and FIFA and the 2006 CAS case of WADA and FPF, it suffices that the addressee had the opportunity to obtain knowledge of the decision. Whether or not the addressee had the actual knowledge of the content of the decision is in itself irrelevant. And in the present case, if I may turn the panel's attention to para 23 of the record located on page 4 of the facts.
Sorry, hold on. Page 4.
Yes, para 23. The decision was fully upheld on 31st March 2026 by the FIFA Appeal Committee. Therefore, the appellant and his legal counsel would have had the opportunity to obtain knowledge of the decision on 31st March 2026. Therefore, the relevant date...
Sorry, I'm getting a bit confused. I'm looking at...
Oh, apologies, Mr. Arbitrator. I meant paragraph 26.
26.
Located at page 5.
31st of March. Okay.
Yeah. And therefore, the relevant date which triggers the statutory 21-day time limit begin on 31st March 2026, making the deadline 21st April. And as a result, the appeal filed on 23rd April, which can be seen on para 27 of the record, was evidently late.
So how many days was it late, right?
It was late by 2 days, Mr. Arbitrator.
2 days.
2 days.
And for that, you want to throw out the appeal?
Well, in respect of this, we do agree that the CAS has been able to allow the extension, not allow the extension of the by reinstatement of certain submissions of documents in light of the failure to submit their documents on time following the deadline. However, the issue of reinstatement is that it can only be granted on very, very specific circumstances. And we argue that it cannot be granted in this case. Firstly, the appellant had failed to act promptly and diligently. And secondly, the appellant had failed to prove that the delay was due to no fault of its own. As found in the 2024 CAS case of SC Football Cup and Galatasaray, a lack of timely action by the council, even against the backdrop of technical issues, creates the fatal presumption that a party simply missed the deadline for no good reason. And there was ample opportunity for the council in that case for the appellant to request for reinstatement.
I'm sorry, so in that case, was there a security breach, cybersecurity breach?
There wasn't a cybersecurity breach. However, we are focusing on the issue of promptness as noted to be a key requirement for the requestment of reinstatement.
Because earlier, I think your opposing counsel did mention that there was some delay due to the cybersecurity incident. But
Yes.
if that was not the case, it would have been on time.
Yes, but we have to consider the nature of the cybersecurity incident because counsel for the appellant has not given the full picture of how the events had unfolded. Firstly, even if we disregard the cyber attack, the inherent nature of emails is that if it had indeed been sent, they'll be found in the sent folder of the council's chat. And even without an error message, the fact that such an email notification was absent indicates that CAS likely did not receive such an email. And if I could turn the panel to para 27 of the record, located at page 5, the appellant's legal team had filed the highly sensitive statement of appeal at 23:45 Iridonian time on the final night, if we do take the appellant's position that the deadline was 23rd April himself, and consider the deadline of the following 15 minutes before the deadline was to elapse.
What's wrong with that?
We are submitting that because the legal team had proactively failed to verify receipt or to follow up immediately to ensure that their statement of appeal was received by the CAS, they should have already contacted CAS to ask for reinstatement at this juncture. And we have
At what time should they have asked for reinstatement?
we submit that it was on the night itself because the deadline would have elapsed, and by the time midnight has passed, they should have checked whether their statement of appeal was actually sent to the CAS.
So how and at what time do you think is the right time or right manner to ask them so that they don't fall foul of this?
I would
Because the fact is that they didn't send it.
They did send it. Okay, but however, we would submit that even if we if we do consider the nature of the cyber attack, we have to look at when the cyber attack was made known to the appellant. And in this respect, if I could turn the panel's attention to Exhibit 9, located at page 19. I understand that the mood problem may not follow the specific. It shows a screenshot of the WhatsApp message between the appellant's counsel and its IT provider.
Exhibit what again?
Exhibit 9.
Okay, that's page 52 of the record. Yep.
Yes. Mr. Fortuna was informed of the cyber attack and its possible consequence on 26 April. Yet, they waited until Tuesday, 28th April, and this can be seen at para 29 of the record at page 5.
Sorry, I'm looking at the WhatsApp.
Hmm.
Cyber security recently occurred. That's on 26, so that was after the incident.
That was after the incident.
Okay.
And then we have to consider when they made known to the CAS that this cybersecurity attack had actually taken place and when they asked for reinstatement. And this can be found at para 29 of the record.
That is page 5, right?
Para 29 and 30 for the full picture, Mr. Arbitrator.
26. Yet to acknowledge receipt. So 26 is what day is it? 26?
26 is a Sunday, Mr. Arbitrator.
Alright. So 24th was a Friday.
Yes, Mr. Arbitrator.
So if I send it on, hold on, they send it on 23rd.
You mean informing the CAS for
When
reinstatement?
did they
Uh,
when did they file it?
they officially filed it on 23rd April at 23:45.
Okay, so that was Thursday, Friday, sent by courier.
Yes.
Okay. I mean, the timelines look a bit. Okay, so you are expecting people to work over the weekend and reach out.
Actually, if we do consider that the weekends are to be kept sacred for the cast members, they should have filed their query on the 27th of April, which is Monday, a working day. So, in respect of that, despite knowing that they had a cyber attack on the 26th and having the opportunity to inform CAS immediately and inquire of them whether the statement of appeal has indeed been sent, they only inquire of them on the 28th of April. And promptness is noted to be a key requirement for reinstatement. And unless I may be of further assistance on the first issue, I'll turn to the second issue. We submit that the appellant's refusal in handing over his phone was unlawful for three reasons. Firstly, the appellant had breached the non-negotiable duty to collaborate under Article 12, subsection 5 of the FIFA Disciplinary Code. Secondly, Article 6 of the European Convention on Human Rights is inapplicable to our proceedings, rendering the appellant's defense of self-incrimination inapplicable. And lastly, even if the privilege against self-incrimination is invoked, it is insufficient to justify his refusal. Turning to our first argument, the FDC imposes a clear, non-negotiable obligation on all participants to assist in establishing the facts of a case, especially when the integrity of sport is at risk. According to Article 12, subsection 3 of the FDC 2025 edition, persons subject to this code shall help to establish or clarify the facts of any case or any possible breaches of the code, and in particular, shall provide any evidence as requested. And this is an absolute duty as noted in a 2022 FIFA decision of Chilean Football Association and Peruvian Football Association at para 131. And if I could then turn the panel's attention to para 20 of the record, located at page 4 of the facts. Mr. Fortuna immediately refused to cooperate when FIFA's representative requested that the appellant submit his mobile phone for the purposes of their investigation, a clear violation of Article 12 of the FDC. And secondly, we understand that counsel for the appellant has raised the right against self-incrimination. However, the appellant's reliance on Article 6 of the ECHR fails because FIFA's investigation is disciplinary and not criminal. If I could turn the panel's attention to para 15 of the record, located at the same page, page 4. The investigation into the appellant is merely disciplinary, and hence Article 6 is not applicable, and this is supported by CAS jurisprudence. In the very case that the counsel for the appellant has cited, the 2017 CAS decision of Jerome Valky and FIFA at para 263, the guarantees recognized in a criminal trial are inapplicable per se in a disciplinary proceeding before the CAS, since FIFA is a private entity and the sanction imposed by the appellant is purely private.
I'm sorry, I didn't quite hear using the guarantees.
The guarantees recognized in a criminal trial are inapplicable in a disciplinary proceeding before the CAS.
What kind of guarantees are we talking about?
The guarantees in our case that we are contending here is the defense of self-incrimination that the appellant is seeking to rely on.
Guarantees by
Guarantees that I would say are, as noted by counsel for the appellant, fundamental guarantees or protections that are afforded to an individual. And this is further supported by the 2023 CAS Award of EDGAS and UEFA, which noted that CAS jurisprudence is clear that procedural rights cannot, in principle, be determined from the point of view of criminal law concepts enshrined in, and I quote verbatim, Article 6 of the European Convention of Human Rights. The strict application of criminal law principles in disciplinary proceedings would prevent the fight against match fixing from functioning properly. And in the context of sport, the privilege against self-incrimination may not be easily invoked in a disciplinary proceeding. However, even if we agree with counsel for the appellant that the privilege against self-incrimination can be invoked, there's a very high threshold to be met. As noted in Velke, the only situation where this privilege may extend to private investigations, which may be applicable to CAS jurisprudence, is where there's a clear and imminent danger that the privilege against self-incrimination would be circumvented, which is noted to be an extremely high threshold. And if I could first inform the panel that CAS in Drome at paragraph 266 noted that real and imminent danger only exists if there's a collaboration between the sporting organization and the public authorities in which both parties would share information which may prejudice Mr. Fortuna's protection against self-incrimination. And the most crucial fact against such a threshold being met is that the Iridonian Public Prosecutor's Office explicitly refused to share evidence with FIFA. And if I could turn the panel's attention to paragraph 15 and 16 of the record at page 4, the prosecutor stated that they will only share information after their investigation was concluded and the case was ready for court. This refusal demonstrates that states' authorities are protecting the integrity of their own criminal process, not using FIFA as an investigative proxy. If there were indeed an imminent danger of rights circumvention, the state would be actively collaborating with FIFA to bypass its own evidentiary hurdles. Instead, the two tracks are operating independently, which negates the claim of a collusive circumvention of Mr. Fortuna's rights under Article 6 of the ECHR.
But what about, I mean, so his father, the player's father has,